Hello, viewers. This is Major General Neelendra Kumar for the YouTube channel Lex Consilium Foundation. In conversation today with Advocate Anil Malhotra. Now, Anil Malhotra is a person who, in the area of international family law, is of world renown. Though he is based in Chandigarh, but most of the time he is traveling abroad, different destinations, living in hotels, and representing his clients before different tribunals and forums. He did his masters from University of London. He is practicing international family law for past 4 decades. Quite frequently, he tenders expert evidence or report in courts, jurisdictions worldwide. He's also a legal analyst, authored 10 books, and he is a fellow of International Academy of Family Lawyers, which is the ultimate renowned apex body in the area of its specialization. I welcome you, Anilji. My first question for information of my viewers, and I'd like to tell you that although your video would be seen by diverse category sphere of viewers, but it is particularly directed at law academic practitioners who want to make a career, who want to know more about international family law. Now, my question to you is that what has created this need for a specialized niche of international family law at a globalized level? And this has happened in the last 10 years. Was there a glut in the entire range of family law that had existed for a very long time? And would you like to explain this, apprise this to the viewers of this podcast?
First of all, thank you, sir, for this invitation and giving me the opportunity to address this distinguished forum by a personality none other than yourself. Coming to the question raised by you, I think over the past decade, there has been such a awareness of rights among parties, children, women, that there is a clamor, there is a need for pressing of family rights, may it be marriage, may it be adoption, may it be surrogacy, may it be cross border disputes. But sadly and unfortunately, the laws which we enacted 5 decades ago have not caught up. A lot of Indian population has gone abroad. There are 34 million of them. They have started using international laws which have changed with time. Our society has changed. People's awareness of rights have changed. But the laws have not changed. So in this, I would say, glut, or in this flux, there is a demand by a lot of people for justification and relief from courts. We have yet to evolve a family law structure in the courts. We have yet to evolve a family law bar. So we find ourselves grappling with this situation in the Indian society, and we have grown so much in numbers that this so-called jam has occurred, and every day more and more problems come, adding to this collection of problems with no solution.
You've well brought it out. And that takes me to my next question that out of India's population of 1.4 billion people, it is believed that more than 34 million non-resident Indians are there in different corners of the world. Uh, should it be believed that these NRIs, numbering 34 million, as I said, they have contributed to the legal problems in India by importing decisions of foreign courts, foreign jurisdictions in the area of matrimonial and allied disputes?
Certainly. Sir, what has happened is that we marry under traditional sacramental laws. We live in a setup of joint families. We try to keep our relationships intact. Now, all of a sudden, there is a spurt of people migrating abroad, and we are more than 34 million. Besides that, people who migrate from India also marry foreign nationals of
Quite
different
right. Yes.
religions, of different backgrounds, maybe same sex relationships, maybe live in relationships, or maybe different relationships. We now see we even have polygamous and polyandrous relationships. Now, in a traditional society, a foreign national or an Indian turned foreign citizen imports a decision, let us say, of breakdown of marriage on no fault principle. Now, in the West, marriage is a contract. It is dissolved for the asking. In India, a marriage is a sacrament. It is dissolved on a fault principle to be established by a court. So the importing of foreign decisions on this delicate relationship of a traditional marriage doesn't find resolution in the Indian system. Plus, our system in handling this matrimonial litigation hasn't got fully equipped family courts nor family law specialists, and there are delays. Now, when a person is sitting abroad, or one spouse is sitting in India, or there is a child custody dispute, or there is a maintenance dispute, you say, I don't want to wait for 5 years. You go to a court in a foreign country, you get a decision in 3 weeks, 4 weeks. If you don't pay, they give it ex parte. But when we bring this foreign matrimonial judgment to India, it has to be tested on the annual of our civil laws, and it doesn't fit in. So what happens? We create relationships, what the Supreme Court said in 1975, limping marriages. You are divorced abroad, you are married in India. So all this has happened so fast that we, despite Law Commission's recommendations, are sitting on old family laws, and Parliament is very busy doing other things. So this is what I will call a quagmire, a pit of sand, quicksand, in which we are going deeper, deeper, and deeper.
Quite right. I'd like to ask you, it is commonly remarked that marriages, Hindu marriages particularly, they are destined, they are programmed in heaven, and they are solemnized, performed in India, and it so happens that they are dissolved abroad, and it is quite common. It is not a rare occurrence. Now, my question to you is that the divorces in such alliances that are announced by the foreign courts, are they valid in India, or is the divorce process to be initiated and undergone once again in India under Hindu law? And lastly, connected with this is that do Indian courts recognize a breakdown of marriage, that means a divorce, which is pronounced by foreign courts?
So let me go a little deep down in our Hindu society or Indian society. There was a time, whether you were educated, whether you were literate, whether you were well employed, you were asked to solemnize a marriage where you perhaps, I'm not talking of now, where you did not even see the bride.
Quite
Your
correct.
parents, your parents said yes, so
Yes.
you also said yes. So you lived in that relationship. Didn't fall in marriage before. You didn't fall in love before marriage. You fell in love after marriage. And if you did not fall in love after marriage, you still carried on with the marriage.
Yes, that was so.
That was so. I remember a very distinguished senior army officer in our family. When he married post partition, he was a very senior officer. And he said he was away, and they said yes. He came straight to the wedding. So that is a society in which we have evolved. But even in India, this society is changing, has changed. There are live ins, there are same sex relationships, there are relationships in the nature of marriage, and so on and so forth. We are using different physiologies, but at the same time, nobody wants to touch the Hindu laws of 1955. Now, in this situation, this jing bang of what you just said, made in heaven, solemnized on earth, dissolved in America. Now, this has parachuted into a war zone all of a sudden, leaving the system in a flux. We don't dissolve marriages because they're a sacrament. All countries abroad, practically every European country, America, Australia, Canada, you name it, there the marriage is a contract. There is ceremony is optional. For us, ceremony is compulsory, registration is optional. So our wheels move anti-clockwise, their wheels move clockwise. So you bring a divorce decree on irretrievable breakdown, which is given for the asking, and it's only matrimonial property and custody of children which is to be sorted out. But in India, you don't get the divorce for the asking. You have to prove cruelty, desertion, adultery, blah, 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 13 grounds. And you probably spend 10 years in doing that. So what is happening is the man says, I am, or the woman says, I'm not waiting. I'm getting this ex party decree on breakdown from America, Canada, Australia, and bringing it to India. It is brought to India. The woman or the man is filed a divorce. That foreign decree is presented. And the judge says, I don't know. I'm not going to recognize this. This is not on grounds under Indian law. This is an ex party. It is on a ground which is not recognized under Indian law. Thank you very much. We'll have to do all the process again.
Yes.
So this is what is happening. But then what is the way out? Now, what I have evolved over a period of time is you have to tell people, listen, do you want to go forwards or do you want to go backwards? Those who want to say we go forward, I said, listen, we have a system under Indian law whereby we can dissolve a marriage by mutual consent. And you don't need to come to India. You can appear through video conferencing. You can appoint your father, mother, brother, sister as your power of attorney holder. He can recognize you on the screen before the judge. So does the other spouse. And you do it by mutual consent. You draw up a settlement, put the foreign decree in the settlement, and then you tell the court that we can't live together. There is a cooling period of 6 months. It is the discretion of the judge. Supreme Court says you can waive it. And in this process, you get a divorce by mutual consent under Indian law. And you impliedly, through the back door, bring in the foreign court decree in the settlement, and you get a stamp on it. Now, if you do this, you are divorced in India also. But the aftermath is, if you don't do this, You can be guilty of, if you remarry, you can be guilty of bigamy in India. You will not be able to resolve your matrimonial cruelty, dowry claims, maintenance claims. And those are all alike. So it is sensible, it is practical, and it is legally valid if you do it and have a proper funeral of your marriage
Okay,
in both jurisdictions.
right. Thank you, because you have clarified the whole issue, and you said that time involved taken in this process may be just say 6 months plus, and that makes it quite clear.
And sir,
But
that may even be waived in the
yes,
discretion of the court.
that can
Now,
be
sir,
waived. Okay,
absolutely, it's,
right.
it is, Supreme Court says it is the discretion of the judge in India
Okay,
to waive it. And
okay.
he can even waive off the 1 year mandatory waiting after marriage before you can file a petition. He can even waive that.
And that is not only lesser in time, but it is the agony trauma is minimized.
Absolutely.
Certainly.
In India,
I'd like to,
sir,
yes,
I wish to add one thing here.
yes,
Sir, in India, it is not the husband and the wife. It is two families. In India's, a man doesn't marry a woman. Two families marry each other.
yes,
The dowry, the matrimonial cruelty, the domestic violence is triggered against all family members, whether they are married, they don't live together, because the law gives you the opportunity. So we as professionals make full use of it.
our culture and traditions are like that.
Yes.
Now, moving beyond,
Sir.
majority of the foreign countries have in recent years brought out their own new family laws. Now, the NRIs who go and are positioned outside, they seek the help, they invoke these newly formed family laws of the place wherever they may be located, and they get a decision from family courts on these family law issues. On the other hand, the Indian laws have by and large remained unchanged. I'd like to request you to please tell the audience here that how do Indian courts per se treat foreign decisions, and when these decisions are brought, they are quoted and explained, put across in front of them in India.
Sir, let us go down to the core of the issue.
Yes,
Which, what is the problem deep down as a foundation? Now, under Hindu law, if you are Hindu by religion, whether you become Australian, Canadian, German, American, or whatever, you remain a Hindu. So, irrespective of your domicile in a foreign country, irrespective of your nationality, citizenship, or residence status in a foreign country, you remain a Hindu, because the Hindu marriage law, Hindu laws have what is called extraterritorial application, meaning the Hindu in you goes with you as a backpack. You can't get rid of the Hindu law. So, therefore, if you are a Hindu, and even if your child, let us say, is born abroad and is a foreign national, even he remains a Hindu. So, what happens? You carry your Hindu law with you. So, if you are married under Hindu law, your marriage according to Hindu law can only be dissolved by a court of competent jurisdiction under Hindu law in India. Now, you go abroad to, let us say, some states in America, you live there for 4 weeks, 6 weeks, or you go to, don't even go, there's a place called, there's a state called Guam in the US. You don't even have to go there. You send a postal request and you can get a divorce by post. So, what is happening? Australia, Canada, American, England, they take cognizance of you because you are domiciled in their jurisdiction. You are living there. 4 weeks, 6 years, 1 year, 2 years. Everybody has a different country. So they say, You are living in our country, you are domiciled in our country, you have a home in this country, you have the nationality of this country. Therefore, our law, European law, Canadian law, American law, will apply to you. And if you, so to say, voluntarily agree and sort out your matter there, and nobody questions this, it's the end of the marriage or it is the end of the relationship. But whenever that foreign judgment based on domicile on grounds of that country, dissolving a Hindu marriage is brought to India, we say, listen, you are a Hindu. You have to repeat the process I just explained under Hindu law. Now, this is called the clash of jurisdictions. This is what private international law was all about. And this, I think, has now developed, emerged, and formed a big, big balloon, which I now call as international family.
Everything has to be done de novo.
Everything has changed. But we are, in our terms of laws, still sitting with the Hindu Marriage Act 1955. We don't want to take breakdown. Now, for the benefit of others, those who understand a little bit of law, what is the Supreme Court of India doing? It is dissolving marriages, not under Hindu law, but under their extraordinary powers beyond all laws under Article 142 of the Constitution, which is meant to do substantial justice in any matter by passing any order. Supreme Court is dissolving marriages by irretrievable breakdown in Supreme Court. But the high courts and the family courts can't do it because irretrievable breakdown is not a ground for divorce under the Hindu laws. But Supreme Court is doing it in a constitutional extraordinary jurisdiction in the facts and circumstances of a given case with no precedent. So the Supreme Court says, listen, you've been fighting for 20 years. Your children have grown. You can't live together. Sort it out. Go to the mediation cell. Bring up a compromise settlement or an MOU. We will give maintenance. We will sort out custody. We'll do everything. And that is what is happening. Now, but is that the solution? No. So what do we really need? We need to amend our laws. We need to put in the Hindu Marriage Act, and we need to empower our family courts. You can't take a 303 rifle and go to war. You need drones now, sir. I mean, last attack, look at it. There were no soldiers, there were no, like in the movies, tanks moving, guns firing, and a surface to air missile. Lord drones. Nobody went anywhere. So,
Right.
So this is what is happening here also.
Okay.
The drone with the Supreme Court. But the soldier
142 has been taken by them to
Yes.
find a solution to such problems.
Sir, 142 is being used everywhere. Adoptions, surrogacy, letting children out, getting children back. Because people are illegally removing children from India, even though the passport said wasn't go. We have reached a situation where law is being taken in one's own hands, which is not a healthy development for a growing country like India, with so much intellectual property, with so much leadership in a stable government, that we have expanded in terms of trade so much. But I have seen high-end professionals, IT experts, surgeons, engineers do crazy things when it comes to child custody or marriage or taking revenge and whatnot. What do we? We need to, as they say, the charity has to begin at home. We need to first sort out things at home. If we have to grow, if we have to give a big peace of mind, we have to grow, we have to do things to find stable family relationships at home. Then only you can go out to work. most people unofficially do prenuptial agreements. Before they get married, they sort out their mess thereafter, which will happen. Nobody knows about it. Because if you tell your parents that I'm sorting out my business after marriage for a divorce, they would think you are mad. But sir, things have changed. Otherwise you start fighting for custody in two jurisdictions. You make the children grow through parental alienation. You disturb children. You bring up absurd situations. So
You know,
we
uh,
we are in the ICU now, sir.
quite correct. One way of looking at this is I was told quite early in my career that law is never helpless. So, in a situation like this, perhaps 142 has been identified by the apex court that it would be able to do complete justice. And yes,
But sir, the solution is just one moment.
yeah,
The solution is in section 13B, 13 of the Hindu Marriage Act or 13B of the Mutual Consent, you should add a ground, 13B3, you may break down a ground, hedge it with safeguards. Put it under circumstances, particularly when there is one party is an NRI and there is already a divorce, and you find a mechanism, an army of family courts. You have to arm the soldiers. You have to arm the battalion and the infantry. You can't let the generals run the war. I am talking in your balance because
yes,
that is an appealing psyche to you to appreciate.
yes, yes.
Sir,
Now, Anilji, moving further, there are cases of inter-country and interparental child removal by the NRI parents and the other NRIs who are married to foreigners. Now, this has created problems in the matters of custody, guardianship, and welfare of children. Now, I would like to request you, firstly, please point out what is the Indian law position in such cases, and also how do the courts in India respond to such problems when they are brought before them, and do the foreign courts in the matters of inter-country, interparental child removal agree to, how do they view foreign decisions?
sir, first of all, I would like to, so to say, elaborate and educate. Where are we in terms of guardianship, custody, in terms of our law? We have a colonial, outmoded, archaic Guardian and Wards Act. Guess what year, sir?
Yes,
1890. It's a relic. It's a piece in the museum which the British made for themselves when they had issues relating to their children when they colonized us.
yes,
They left this relic and we are still using it. The Hindu Minority and Guardianship Act of 1956. We have evolved, we have made the father and the mother as natural guardians. And we say ordinarily a custody of a child less than 5 years of age should be with the mother. The Supreme Court has broken the gender bias in a decision of Gita Hariharan and versus Reserve Bank by saying mother and father are equal. Then in Lahari Sakamuri, the Supreme Court says plus year 5 minus 5 father or mother is immaterial, which is good thinking. But sir, suppose there is an infraction of law. Suppose there is grabbing of children, or I would say, or there is wrongful removal of children. Now in India, if one parent does it, qua the other parent, it's not a wrong, it's not an offense. I can't walk into a police station saying my child is kidnapped. If I go to the police and say my child has been kidnapped, they say, who took your child? Oh, it's my wife or my husband. They'll say, so sorry, we can't do anything. I can't go to any court saying, oh, this has happened. So what do I do? When I have a difference of opinion with my spouse abroad, I remove the child in violation of the law of that country and bring the child here. Now, the international law on the subject is the Hague Convention on Civil Aspects of International Child Abduction in 1980. It's a convention by the Hague Conference on Private International Law, which binds 110 countries who have acceded to the convention. So these 110 countries operate through this law by which every country creates a mechanism to entertain applications for removal or send applications for removal, which is called the central authority in that country. And wrongful removal or detention of children is defined in the convention. We have not signed this convention. We, in India, we take part in the conferences and the discussions in the Hague. We have signed the adoption convention, but we have not signed the adoption convention. We are guided by the United Nations Convention on the Rights of the Child. Now, in that, wrongful removal is not existing. So this is the clash of interpretation. Child removed to India, according to the foreign country, it's wrongful removal, child abduction, blah, blah. In the US, it's a federal offense. You can be put to jail, you can be handcuffed, you can do anything. Every states have a different law, but this is a UNCGA. It's a federal law. It applies to the US. They're very tough about it. So India has become a haven for parking children when there is a problem abroad. And unfortunately, this is done to settle scores with your spouse. And the sufferer is the child who doesn't know what's going on. He becomes polarized and he becomes alienated. And as very well described by Honorable Justice Sikri in Vivek Singh versus Rumani Singh, he goes into a shell and he suffers from a psychiatric disorder recognized by WHO and which is called parental alienation syndrome. He starts thinking against the parent because he's not there for him, he doesn't understand. So these kinds of issues crop up. And what does the parent who has removed the child to the foreign country do? He rushes to the guardian judge or the family court and requests the court in a petition for guardianship under the Guardian and Wards Act of 1890, read with the Hindu Minority and Guardianship Act, seeking sole custody and sole guardianship. Now, sir, you look at the anomaly, you look at the mess of law. The Hindu Minority and Guardianship Act says we have no remedy to go to court. There is no provision. And the Hindu Minority and Guardianship Act is a subordinate legislation under the Guardian and Wards Act. So we have a stepmotherly Hindu law with the main parent being the Guardian and Wards Act. And once you go to court, you start proving to the family court or the guardian judge why I am a better parent, why the other parent is not a good parent. Now the problem is, who's talking about you? You may be a very bad husband, you may be a very bad wife, but you are very good parents. So in this fight of egos and who is a better parent, nobody talks about the child. I have assisted courses in amicus. So if there is a guardianship petition, it's a copy of a divorce petition. You are flinging mud at each other. So in the bargain, the child custody, the child's issues get lost.